Matter of the King on the application on Pleas and the Secretary of State for Work and Pensions, Park Head.
Good morning. I'm sorry we're slightly late.
Lady, I've just noticed you didn't give the usual warning yesterday about live streaming and contempt of court. I don't know if that's because the banners are contained in the live streams themselves, etc. I just thought, having belatedly remembered it, I should probably mention it.
Yes, that's a good point. Well, obviously this is being live streamed today, and the usual warning applies in relation to contempt.
Well, I'm sure anyone rash enough to have got their recorder out will have stopped it now. Yesterday I've been going through the facts. There's just two further factual points I should mention in completeness. The first is that I failed to show you the decision at supplementary bundle page 223 to 224. This is the decision by which my client was given LCWRA after the initiation of the proceedings, but it's nevertheless relevant. My client is entitled to that enhancement, and that was on the basis that the extent of his disabilities was such that he qualified for that enhancement to universal credit.
Did you also show us the actual decision refusing universal credit, the 13th of November 2020 decision, I think?
I didn't. You're quite right, my lord. It's a very short document, as I recall. That's the first hit for today.
Yeah, well, I know, because I came in and I said Thursday morning. I thought, great.
1 minute, 30 seconds.
Sorry to be grim.
The second thing...
Sorry, now I lost the page number, the first one. I didn't write it down. What page number was it? The one you just showed us? 223
to 224.
Yeah.
The second thing I should mention, at the request of Miss Clement, is that since the updating note filed before Mr. Justice Swift in December, I think it was, my client did briefly return to work, and the Secretary of State has some information from his then employers at Sainsbury's as to how much he obtained from them by way of work. Since that's been put in issue, we will file, just as we did beforehand, a very short letter updating what happened. Broadly speaking, much as before, it didn't actually prove a success in the end. And it wasn't.
But he's tried absolutely everything he can to work.
Absolutely.
He's done the shifts. He's stood on his feet for hours in the bar. But with the medical conditions he's got, with the best will in the world, when he goes back, he's exhausted.
And he keeps on trying.
And he keeps on trying. But I mean, should we be having new evidence? Don't forget, this is an appeal, not judicial review. But you say it's not you. You say it's Miss
this one I get to say, it ain't me.
Yes, right, okay.
That's Miss Clement's point, and she wants the court to be updated. If you think it's relevant, we'll provide that information.
I don't think it's necessary.
Actually.
Grateful. So, the grounds.
Well, what about the decision? You were going to show us the November decision.
The refusal of UC.
The one that's actually the subject of the JR. I just would like to see what the Secretary of State said about it. I assume it's short.
Trying to remember off the...
I couldn't track it down this morning.
228 of the core bundle, Mr. Royston.
228. Oh, it's just a screenshot from your universal credit log.
That's it, because the system is designed to be a computer says no system.
Yeah.
There's no substantive consideration, and that's the system that it's so urgent to preserve, because what the Secretary of State is anxious to ensure is that there is no requirement in the system for any substantive consideration of the position of any.
And the reason is you're in full-time education, she doesn't say, and you don't qualify for the... yeah. Okay.
Maintaining the existing system turns it to a straightforward box-ticking exercise.
Yeah.
So the grounds. The first is rationality. Can I make a couple of introductory points? The first is that this ground is, in fact, as I said yesterday, closely linked to the PSED. Why? Because consultations are the means by which decision makers acquire not just submissions, but also evidence, or are alerted to further areas of relevant inquiry. And the fact that no consultation has occurred is, for that reason, highly important context for the second challenge. And you have my point that the PSED challenge is not, as it sometimes is, some form of make-weight. It is a substantive and vigorously pursued argument in its own right.
Yeah.
Secondly, it's necessary to ask what the point of any potential consultation under discretionary consideration was. And that point must have been, and can only have been, to obtain views on the merits of the no new claims policy, which was to be put on a lawful footing for the first time, and which would thereby impose further lawful restrictions on the ability of disabled people accessing benefits despite entering tertiary education. It is a new legal restriction enacted for the first time. The 2013 regulations had added the requirement that you had to have an LCW assessment, and it is only the 2020 regulations that added the requirement that such assessment should be made and obtained before you made a claim. Now, before the judge, this case was run on the twin basis that there was, first of all, a common law duty to consult, and secondly, that there had, if no such duty, been an irrational exercise of the power to consult.
Yeah.
And it's only the second argument we maintain. The irrationality lies in the conclusion that no consultation was necessary. Why? Because the 2013 regulations restored the original policy intent of the 2013 regulations.
But that's not the finding of the judge.
No, it isn't, and I'm going to come to that, my Lord, because with respect to the judge, he has re-rationalised, impermissibly, the Secretary of State's reasons. The judge's reasons are in core 95, and they start at paragraph 12. Paragraph 12 sets out the introduction to the point. 13 to 18 deal with the duty to consult point, so we can skip those. And the material analysis begins at 19 through to 22. Now, the first thing to note is the reasoning at 20, where the judge, in effect, dismisses as irrelevant all of the statements about what the intention of the Secretary of State was in introducing the bill and the regulations. Well, with respect, first of all, that ignores the statements, and it doesn't cite the statements in the explanatory memoranda and the reports prepared by SSAC itself about the regulations, which are directed at Regulation 14. And you'll recall I showed you those yesterday, and they show no trace of the no new claims policy at all. But secondly, with respect to the judge, what he's missed is the relevance of this material. Because the relevance of this material is to show that no one, no reasonable person, could ever have thought that there was a no new claims policy at the time. And why is that relevant? Because it's relevant to the Secretary of State's actual grounds for deciding not to consult, which was restoring the policy intent. It shows, and I don't think that there is actually any factual dispute between us on this point, but whatever the subjective intent of the minister or her department at the time, there was no objective material that communicated that to anyone. The obvious relevance of that is that that earlier policy intent and the earlier consultation on the 2013 regulations cannot and did not generate any response directed at the lawfulness or desirability or merits of the no new claims policy. That's why it's relevant. Then at 21, the judge goes through Badu and Kauser and points out that all of this explains the rush. Mm. But again, with respect to the judge, what he doesn't do is draw out the important point that those cases show that not only was the no new claims policy not trailed in the 2013 regulations, it goes further than that. The no new claims policy was incompatible with, inconsistent with the regulations. And that must be a factor that goes into the balance when deciding on whether to consult. Then one comes to paragraph 22, and this is really the core of the judge's actual reasons.
Yeah.
What he says in effect in the second sentence is this: the reference to there being no consultation because there was no change of policy amounts to the Secretary of State saying that she saw no need to consult because the policy, the amendment the 2020 regulations pursued, had already been the subject of consideration within the department and had been determined to be appropriate. On the evidence I've seen, this has been the position since early 2017. The Secretary of State's reason was to the effect that the consultation
Was not
to be made. The consultation already occurred, and then the brackets are important, which would have been incorrect. So it's accepting no effective or any consultation on the policy.
Yep.
Rather, it was that she did not consider there was any need to consult on a settled policy position. Now, with the very greatest of respect to the judge, that is not the Secretary of State's actual reasoning.
Well, you've got to look. You're going to show us Gannon, but don't forget to show us the explanatory memorandum as well.
My lord, I was going to show you the explanatory memorandum.
Right.
I was going to show you the submission to the Minister and Miss Garrett's evidence.
Yep.
All three of which are inconsistent with the judge's re-rationalisation. So let's start with the explanatory memorandum, page 162 of the supplementary bundle. Paragraph 2.1, because you have to read all of these paragraphs before
Sorry,
you get...
give me the page number again.
Page 162.
162, thank you.
Paragraph 2.1, what's the purpose? It's clarification of the exception that was intended to be contained in the 2013 regulations. A critical person might say that's slightly tendentious, there's nothing to clarify. It's actually completely recasting. But that's actually...
Fairly usual language though, isn't it?
Yes, it is. It's, again, Sir Humphrey speak. But the very fact that it's formulated in those terms then comes to be relevant later on, as we'll see. 3.1 to 3.2 shows the other thing that's in play here, urgency because of the desire to have continuity of the computer says no approach. 7.1 to 7.3, the amendment restores the policy intent, which was arguably not supported under the existing framing of the regulation, more Sir Humphrey. The policy enables disabled people already assessed as LCW to enter or remain in. The purpose is not to enable, etc. And then all of that feeds into 10 under the heading consultation outcome. This is the reason. This is the reason one has to grapple with. Given that the amendment restores the original policy intent, and that is and can only be a reference to the original policy intent of the 2013 regulations, no consultation has been undertaken. So that is the operative and the only reason that is given. And with respect to the judge, of course one could come up with any number of perfectly defensible reasons.
But I mean, isn't that what he's saying when he talks about a settled policy intention? I mean, that's what he's referring to, isn't it?
With respect, the reference to 2017 suggests it's not. What the judge is saying in paragraph 22 is that this policy has in fact been operated since, and because of that, presumably the Secretary of State has learned all that he or she wants to know about the policy, and for that reason...
Well, is that right? Isn't he recognising that there was the intent in 2013, badly implemented and not clear externally, and it became clear over time so that by 2017 it was a settled policy position?
Well, I suppose one could read it that way. That, I must confess, isn't how I had read it.
Isn't the contrast this? We know she's under no duty to consult,
Yes.
or she doesn't have to. And the contrast that's been drawn in 22 is between a situation where she says, I don't need to consult, I've done it. That, he says, would be wrong. But she says, I've always wanted to do this, and I'm going to do it. And there's no point consulting, because I don't want people to tell me not to do it, because I'm going to do it.
But-
That's the contrast that he's drawing. This is my policy, I'm not going to consult on it, and I've already done it, so I don't need to do it again. That's all he's saying, isn't it?
But with respect, my lord, that's not what paragraph 10 says. It's not what paragraph 10 says.
No, but the point is, nowhere does the explanatory memorandum say this. We consulted on this, and we don't need to consult again. What it says is, there was an original policy intent, and its words after that. Nobody knew about it, because if they'd read the draft regulations, they wouldn't have appreciated it, and so on, and it didn't become clear until 2017. But the contrast is, in a situation where you don't have any obligation to consult, and you have to establish irrationality, and the explanatory memorandum says, this is what we attended originally, and that's why we're not consulting. Not that we've done it, and we know everything that people are going to say. The question is, where is the judge going wrong in saying that's not irrational?
If that were the approach, my lord, why doesn't paragraph 10 simply say, we've considered whether or not to consult and decided not to?
Because then you would have said, you haven't told us why you're not consulting.
Clearly, the Secretary of State has divined something of relevance from the fact that this particular regulation is designed to restore the original intended policy. It's that fact that the Secretary of State is attaching importance to, indeed decisive importance.
Yeah.
It's
She
that-
doesn't want to consult again on it because this is what she's always wanted to do. Not that she's got the material from an earlier consultation, which is what was being said in 22.
But the intention in 2013 presumably was that there should be determinations rather than assessments. I know it didn't say it on the face of the regulation, and that was not found to be the position, but that was the evidence is that was the policy intent. It only became clear to the external world that was the policy intent by 2017.
Yes.
And potentially only clear within
Potentially within the
as a
department,
whole.
because it took a while before students started to go through these processes and be refused.
But with respect, how is the fact that that is the original intent rationally related to the decision as to whether or not?
Because she doesn't want to get people to help her formulate a policy. She knows what a policy is. She knows what it is for some time. She's been cack-handed in trying to get it implemented, but she knows where she's going. She doesn't want in 2020 to say, right, I'm going to start again, let's hear what everybody's going to say about this, because I don't want to know what everybody is going to say about it, because I know what I want to do.
And it's also relevant, isn't it, that this is a world in which students don't get universal credit. This was an exception made for those with disabilities to encourage them.
Yes, but it's also relevant, my lady, that this is a further restriction from the position that previously applied.
It is.
And had been said in general statements and more, would in general continue. So it was a further
There's
unheralded...
no legitimate expectation case based on
No,
those
but
statements, and the judge said that they're
No.
terribly vague.
No, but the point I make is that the basis for not consulting is grounded in the fact that the original intent was that there should be no such entitlement. And one has to ask, how is that rationally connected to whether or not you should decide to consult? Let me give you an example. Suppose I conduct a consultation as to whether or not to close a hospital X. And suppose I keep entirely internal to me a consideration that the reason I'm going to close hospital X is I think the patients can go to hospital Y and will be adequately dealt with, their needs met at hospital Y. I never communicate that in the course of the consultation. Could I answer a complaint that I hadn't reconsulted once that was my view because it was material to the final proposal, etc., by saying, well, it was always my intention to do that. I always thought it. The fact I didn't communicate it is neither here nor there.
But would that change? Would that change if a part of the hospital moved anyway? Even the, I'm trying to use your example, which is quite difficult. She proceeded on the basis of that settled policy for a period of 3 years. That's the point, isn't it? And having done so and regarded it as working, even though unlawful, she is making lawful what she had already intended, and that's why it was not
But that's,
necessary to
with
consult.
again respect, that would be a good reason if that was the reason communicated. But it's not.
But that's it. Isn't that what's being said here? She's got a policy intention in 2013. It's not clear to the world, and it may not be internally clear within the department. It becomes clear over time. By 2017, it's a settled policy. That's the way it's being done. So far as universal credit is concerned, it's working from that perspective. It's unlawful because on the face of the regulations, it wasn't permitted. She is now putting the position right and making clear that the original policy intent has been properly implemented.
With respect, my lady, what you're saying is that the real decision is that I've decided not to consult, notwithstanding that the policy I previously implemented was unlawful. Why? Because I have implemented it already and learned what I've learned from its unlawful implementation. Now, that is not in any way or anywhere spelt out in this document, the explanatory memorandum. Indeed, the explanatory memorandum, the submission goes out of its way to effectively obscure the fact that the policy was unlawful. Now, if
Don't forget, the starting point is there is no obligation to consult, full stop.
yes.
She could, if she wanted, to do lots of things. One of them is consult. And you have to show irrationality,
Absolutely.
which is very high. And I know that we're talking about the reasons for it, but if you look at the words on 10.1, and more importantly, if you look at the conclusion that the judge came, because this is an appeal, and when he contrasts, it wasn't that I've already done it and had the information, I'm not going to do it because I've been, as my lady says, doing it for the last little while anyway. You have to show that's irrational, that nobody could reasonably take that view.
If that is the correct reading of paragraph 10.1 of the explanatory memorandum and of the submission to the Minister and Miss Garrett's evidence, all of which continually refers to restoring the original policy intent, if that's the real meaning of those words, then I would submit that where you're in a situation where you've gone from taking into account an irrelevant consideration, because the original policy intent of the 2013 regulations at that point in time, back in 2013, is completely irrelevant once the no new claims policy is shown not in any way to have been communicated.
No,
You're moving from
Why
that.
why is it irrelevant?
Why is it irrelevant?
Yes.
Because if you're simply saying, stopping the clock at 2013, my internal uncommunicated intent was to introduce the no new claims policy, and the policy hasn't thereafter been implemented, that's irrelevant.
But it has.
Yes, I'm coming on to that. If you're saying that the real meaning of paragraph 10 is what is relevant, is the settled practice of operating an unlawful policy, then in my submission, the claim turns from one of taking into account an irrelevant consideration to failure to take into account a relevant
The
consideration.
purpose of consultation is to help you formulate a policy.
Absolutely.
You're saying to yourself, shall we have wind farms in Wales? Let's see what people in Wales think about wind farms. Everybody will write and say, this is lovely, we don't need wind farms. This is not that situation. She's not formulating a policy on whether or not students should have applied. She's tried to formulate it, she's gone about it the wrong way, and it was found to be unlawful. And she's going back to doing lawfully what she's been trying to do for 8 years and got it round her neck. And the question then is, does she have to consult? She didn't have to consult at all, because there's no duty to consult. She doesn't want advice on what the policy should be. We'll come back to PSED. And therefore she decides to go ahead and not consult in a situation where she thinks it's urgent, because she hasn't done anything in response to the first tribunal. She shouldn't be where she is, but she is. And the question then is she irrational?
On your point, you can't just read 10, as you've already pointed to 3.2. It makes it clear in the same document that this is a policy that they've been seeking to implement.
Of course, and it also makes plain
Yeah.
that also a factor in play is the perceived urgency.
Yeah.
So there's two factors in play. It's restoring the original policy intent and urgency. But it's only the former that we challenge. The point I was trying to make to my Lord Justice Lewis is that if you approach, I shouldn't use the pejorative word re-rationalise, if you read 10 as embracing the factual history of implementation of the unlawful policy, which I confess we didn't and never have, if you read it in that way, then in terms of Wednesbury, you're still in Wednesbury Link 1, but you've moved from taking into account an irrelevant consideration, which is an uncommunicated intent, because that can't be relevant to whether or not you decide to consult or not.
No, of course it is, because consultation is to help you decide what your policy is. She doesn't need any help. She knows what it is. Her problem is different. She can't get it right. Not that she doesn't know what she wants to do.
Well, let me finish my submission before my lord shoots that one down as well. You move to a situation where actually the relevant consideration is that there has been no consultation in the 2013 regulations when the Secretary of State has been consulting and inviting views upon this change in the system. And notwithstanding that, they have operated an unlawful policy, which there has been no opportunity to gather evidence about in a reasoned and reasonable fashion. That then becomes the relevant consideration. Should I proceed, notwithstanding the fact that there has never been any opportunity to make submissions in relation to this legal restriction on entitlements of disabled people?
And different people may respond differently to that.
Of course.
We might have had a more meticulous Secretary of State who decided to consult on that basis. But is it irrational?
Yes,
not
it is.
to
It's
have?
limb 1 of Wednesbury. It's the failure to take into account a relevant consideration at that stage, because you haven't taken into account the fact that you've never consulted upon this particular policy and you've gone ahead to implement an unlawful policy.
But there's nothing to suggest she thought she had consulted.
No, there isn't.
So,
But there's the background of consultation in relation to the 2013 regulations. The whole point of the 2013 regulations and the very extensive consultation that went into it, exceptionally, was to flush out all views about the impacts of these measures on all affected parties.
And she did manage to flush out the views on this.
She
And the
didn't
question is
state-
whether she's got to do it or be castigated as irrational if, when she's been doing it for years, she comes back and...
but you say she didn't
right.
consult on this because it
never
wasn't on the
consulted.
face of
Okay.
the... Yeah.
Are you saying it's unreasonable for her to fail to take into account that she did not consult? She should have turned her mind positively to the fact that she did not consult on this in 2000. Is that what you're saying?
And to the fact that if we're relying on the period of implementation, it's unlawful implementation that wasn't accompanied by any form of inviting views about the policy that was being operated. The policy was just gently percolated into the operation of the system. And that's why you get the letter from Disability Rights UK in July 2017, when the penny finally dropped, saying, you've never asked us for our views on this, and it's a hugely problematic problem for these reasons. Now, in deciding whether or not to consult, surely the Secretary of State, acting rationally, has to confront the fact that the only way the policy has come to be operated is by accidental intrusion, evading the consultation that should have attached to the 2013 regulations.
No, that's not right.
Yes.
There was no obligation to consult in 2013. She chose to do it, but there was no obligation to do it, and it didn't generate a legitimate expectation.
The point is, my lord, that there was a discretionary decision taken to consult in relation to the 2013. Why? Because of the obvious wide-ranging policy impact of those regulations. And if the policy intent had been communicated, the Secretary of State would, at that stage, have received submissions on it from DR UK, no doubt, amongst many others.
And that didn't happen.
It didn't happen. The whole reason why the first regulations are, in many respects, exceptional, and this is true under all the Brexit regulations where you get these new...
Let's talk into Brexit.
No, the very reason why the first set of regulations made under these skeleton powers attract consultation is precisely because they are policy-rich environments where changes like this are made. And what's happened is that this policy change has slipped between the cracks, and it's not an insignificant policy change. That's the issue. And so if you read the reason given in the way the judge does, and I'm obviously pushing in a firmly closed door to suggest otherwise, if you read it in that way, that takes you to the logical position that I just identified, which is you've got to confront the fact that the policy has slipped between the cracks in terms of the consultation you've previously exercised, and therefore, that is a relevant consideration for you to address before deciding whether or not to consult again. And there is no trace of that in the decision. And that's not surprising, because the submission to the Minister doesn't fairly grasp the nettle in relation to those issues. We get all the Sir Humphrey language. Now, I was going to show you the submission as well.
There's nothing in the explanatory memorandum about the earlier consultation, is there?
No.
Sorry, I interrupted you.
So, insofar as the submission grapples with this issue, I think it's paragraphs 10 to 11 at page 142 of the supplementary bundle. Technical moment, I think it's called. Vainly striving to transfer myself to paper practice, but I'm beginning to become moderately competent at it.
Well, I was very impressed so far.
I take nothing away, my lady. I at least have it. Page 143, paragraph 10 to 11. And you see the same language about restoring the policy intent, etc. And it is, with respect, still clearer in Miss Garrett's evidence.
Well, look at 18 as well, too, actually. You've got to look at it all.
Yes?
No proactive handling is planned. There is no change proposed to the current policy. If the parliamentarians press for a change, you are prepared to commit to reviewing the wider policy of access to UC for disabled students as part of
I think, with respect, my lord, that's not actual reasoning. That's telling the Minister how it's proposed that the department will handle any pushback in relation to the policy.
I don't think
that's
But it does show you what they think, that it's
it
no change to the current policy.
Forgive me. It tells you, in common parlance, how they're planning to sell this to the public.
Yes. And it also helps by telling you why they think they can sell it to the public in that way.
Yes.
Because of the first sentence.
Yes. If one looks at Miss Garrett's evidence at page 118, paragraph 23 starts this analysis of the policy intention, restoring the policy intention. And if we go through the materials, you see it starts off with material suggesting, and I went through this yesterday, that the policy intent was clear even before the regulations were made, and I've answered that it wasn't. But then through to 32.1, where you've got the considerations at the point in time of Badu. The original policy intent can only have been that back in 2012/13. You've got 35 to 36. 35 at the end saying they've decided that in order to reinstate the original policy intention, she'd need to amend the regulations. 36 introduces the submission, and then 39, addressing the explanatory memorandum, confirms the amendment restores the original policy intent. It also confirms that as the amendment restores the original policy intent, no consultation was undertaken before the regulations were made. Not with respect unpacking it in the way that Mr. Justice Swift has done, or this court suggests is to be unpacked. It's simply that the original policy intent, i.e. back in 2013, was the reason that no consultation was undertaken. Now,
sorry, I haven't found, did you see paragraph 39 and 124?
Last sentence.
124, last sentence.
Oh, hang on. Oh, yes, I see, yes. Yep.
Now, if nothing else, I hope we can agree that if you don't unpack that passage in the way that Mr. Justice Swift does, the decision would be irrational.
Not necessarily, but we've been there. We've done that.
I'll move on. The next ground, ground 4, the PSED. Now, this argument was given relatively short shrift from the judge, no doubt because he thought it was a make-weight. The reasons are at page 105 of the core bundle. And it's paragraph 38 and following. Can I ask you first of all to note in 39, the last sentence, for the purposes of compliance with the PSED, whether this policy was a new policy or a restatement of an existing one is not to the point. What matters is that there was consideration of the practical change to be made. With respect, that's wrong.
Wrong.
That's wrong. Because the passage in bracking makes it absolutely plain that what has gone before, as well as what the position is now, is of relevance.
But isn't
Well-
he saying there, let's not play with words, what is the purpose of this assessment is they know there's going to be a change in the legal universe. Something which wasn't legally permitted before is going to be legally permitted afterwards.
If that's what's been said, then I agree, so long as you also take as given that what that compels you to do is to examine what happened in the past during the period of the policy's operation.
Well, this is a process outcome rather than a process
Duty.
provision, not an outcome provision.
Yes.
And so long as the impact in relation to protected groups is recognised and confronted, that is all you can ask for, isn't it?
Well, it starts before recognised and confronted. It's investigated, recognised and confronted.
Well, you need to investigate it if you don't know what the impact will be.
Correct.
But if you know that the impact will be that disabled students who don't already have a determination will not get universal credit, and you as the minister know roughly the value of universal credit, then is there really anything more to invest? Obviously, in a perfect world, one could have the exact numbers and the exact amounts and the scenarios that you've identified. But in an imperfect world, so long as you know what the impact is and you understand the core effect of the policy on the protected group, are you not discharging your PSED?
No, if you don't know what the impact is on the protected group and the size of the protected group. No, if you don't know how many.
So you say when you say you don't know the impact, you do know the impact. The impact is you'll lose universal credit. It may be that it's made up, or it may not be made up in student grants and bursaries and all the other private sector funding that might or might not be available. But at worst, universal credit is not available to that individual.
What the
That's the
EIA
impact.
does is say, if you are caught by the rule,
Yeah,
in general terms, this will be its impact.
yes.
And that, with respect, is not enough to discharge the duties under section 149, because you need to know how it impacts upon the disabled class as a whole and how it affects opportunities. So to understand the impact of the rule, you need to know, and except you might have to use approximate figures, but there aren't even approximate figures. How many disabled people are affected by this rule and how many people are not? You also need to know, in my submission, the rough order of magnitude of the likely impact. Why? Because the justification latched upon by the Secretary of State is that whatever impact there is, it will be addressed by alternative provision.
No,
Not will be, may be mitigated.
Will, may is likely to be, there are means to mitigate it.
Well,
Whether
it's
or
not
not-
as Panglossian as the bracking,
Well,
is it? Or do you say it is?
I do say it is.
Okay.
The Secretary of State's case is that there's an array of alternative modes of provision, starting with DSA.
no, I think you're being unfair there. there is a range of alternatives for living expenses, and there's also certain things for disabled students which, reading it fairly, the implication is the writer of this thing knew that those things were for the special stuff. I don't think they're saying, but I mean, it depends how you read it.
It's interesting that you say that, my lord, because if you look at the actual EIA itself,
Yeah.
that is not what it says. And indeed, the EIA itself,
And what I was thinking, I mean,
which ones has
I'm
starting
just looking at the
147.
second sentence under evidence and analysis. Although some disabled students may not be able to receive universal credit, they can, as all other students, access fees and living costs, which is what we are talking about when I talk about the ordinary student costs, for their higher education courses through various loans and grants funded through the student support system. They will have to do their living costs, just like others. And then there are other things for their disability. Your additional point is that in the real world, a lot of people are going to have to work part-time in order to fund their studies. And as we've seen, Mr. Case has tried his absolute best to work part-time, but given his disabilities, he's not going to be able to do that in the same way that somebody who doesn't have those disabilities has. And there may be other people in a similar position.
Yes, the student support language is used throughout the equality impact assessment to refer compendiously to a whole series of means of assistance. But it's absolutely plain that that was thought to embrace DSA. And you see that from page 150 in the very...
Yes, but it says includes.
Yes, but with respect, it's completely irrelevant. Why? Because an existing claimant can access DSA, and an existing claimant can get DSA. Why? Because it's a form of expenditure that's unique to going to university. It doesn't move the dial in terms of the difference in treatment between the two cohorts one jot. And that's why, with respect, there is no provision in the regulations, according to the regulations for maintenance grants, saying that the receipt of DSA should be taken into account as income. It's completely neutral. It doesn't address anything. It addresses equal needs of existing and new claimants in exactly the same way. It doesn't alter the analysis at all. It's completely neutral. So the reality is, and we'll get to this when we come to ground 3, the reality is, what the Secretary of State is really saying is that the people in the new claimant cohort should either trim their sails by not going to university away from home or by going part-time, or that they should expect to find the shortfall in the money that they need to meet their living expenses, so without dipping into their PIP, which is meant to be used to treat their disability, from either charity or discretionary bursaries.
Well, what this seems to be saying to me is that their living costs and their tuition fees have got to be accessed through the student support system as it is for everybody else. And your point really is that they're not like everybody else, and they won't be able to do some of the things that other people would be able to do without the disability. That's really, I think, what it comes down to, but you disagree.
The student support system, the maintenance grants, are also awash, because you've seen the calculus that shows that you're expected to treat those as income and your universal credit will go down.
No, that's a quite different point, actually.
Well, as I understand the Secretary of State's case, the position of new claimants is they are expected to meet their needs, which would otherwise be met by universal credit, by either maintenance grants, DSA, other discretionary payments of that kind available, and indeed the Secretary of State doesn't suggest through work.
Quite rightly.
That's not in the EIA or the memorandum at all. That's not surprising when you consider the definition of those entitled already those for LCW. So it's not reasonable to expect it. So you can eliminate DSA because it's a wash. You can eliminate maintenance grants because the regulations treat them as income and reduce your universal credit to a sum which you otherwise won't get from maintenance, and you are left at that stage.
That's not the point I'm making, and with respect, I don't think it's the point that's being made here. It's a simple point, and it's this, but we don't need to spend any more time on it. The only point that I was making is if you read the document fairly as a whole, if you were a non-disabled student, you would expect to meet your living costs and your tuition fees through the student support system.
Yes.
If you're a disabled student, this document seems to say you're going to have to do the same. There are other things that will address some of your disabilities, but your living costs and tuition fees would be met through the same mechanisms as non-disabled students are. What I had thought the real problem was that you were saying that fails to realise that people who are disabled, like Mr. Kayes, don't have the same opportunities to recoup their living costs, for example, by working long hours or whatever, that non-disabled students have. So that's why, that's the only point I'm making, and all the other points you make are very interesting, but they don't go to my reading of the document in that way.
100% agreement with my lord, once again. 100% agreement. The critical factor is that new claimant students, just like existing claimant students, because the relevant cohort is people who have LCW, cannot be expected to work.
Yes,
And
that's
therefore the package that works for an able-bodied student
Yeah.
who is expected to work in the hours that they're not studying during term time and during the holiday cannot conceivably work for them. And that's the point made and answered at great length in Mr. Kay's circumstances to explain why that can't possibly work for him.
Yeah.
And we would
that's
suggest
the missing bit.
Yeah.
that's the missing bit, but that's in no way and in no part of the EIA addressed. And it comes back to the key point, which is the position of the new claimants and the position of the existing claimants is exactly the same. How can it be that there is a deterrent effect on existing claimants from the threat of their benefits being taken away without the same deterrent effect operating on the new claimants who, like the existing claimants, cannot be expected to make up the shortfall in benefit through work?
And isn't the answer to that given in the EIA that they will know in advance that they're not going to get UC, and they will have to make a choice about where to go to university and how to access tertiary education? But I mean it's harsh, and you may say it's grossly unfair, and but at the end of the day, these are limited resources, and a policy decision has been made to honour what is existing, but to where people don't have access to that benefit already, highlight the fact that they've got a choice to make.
I think we are, with the greatest respect, slipping into ground 3.
Are we?
Because,
I thought I was looking at the EIA
because
that's it. The minister was confronted with a situation in which the document made clear that universal credit was going to be honoured for those who already had a determination, for those disabled students, but not for the others, and was told that for those others, they would have a choice.
my criticism at this juncture is that if that is what is intended to be conveyed by that last sentence, it is not sufficiently unpacked as per the Don case cited in Bracken, because the minister is required clearly and unambiguously to confront what's going on. What the minister is not told is that, notwithstanding that the general policy in favour of existing claimants is that they should be supported, why? So that they can upskill and thereby increase their prospects of actually being able to work, not being dependent upon manual or other such labour, but having a degree and accessing a different part of the job market. That's the policy. That policy is effectively not going to be applied or applied with the same vigour to those who haven't made a claim. Now,
Isn't that perfectly obvious?
well, with respect,
says
it
it.
isn't, my lady, because it doesn't spell out in even simple terms that the consequence of this policy will be, first and foremost, that those with straitened means will be forced to choose courses next to their home. That's a lottery. What if you live in Lincolnshire? What if you live in the countryside?
But it
Where are you
says
expected to go to university?
I'm so sorry, Mr. Delamere. Top of page 150, first substantive paragraph, halfway through, it makes it clear that they, without a determination of LCW, they may cease to be entitled to UC if they continue with their intention to go into education, and the choice rests with the claimant. Now, I know that their opportunities are limited, and it's harsh and, for many, unpalatable, but the position is actually spelt out, isn't it?
Well, in my submission, the very least that is required is to identify the rough numbers of people that will be affected annually by this policy, using the best data available. The rough numbers of people who are not affected by the policy, i.e. the existing claimants, because that goes to the fundamental question of fairness. In circumstances where we are talking about relatively arbitrary lines being drawn, they are arbitrary.
Okay, and so
And you need to know, and it was obviously
much?
calculable, how much the gap is. Because knowing how much the gap is relevant to working out whether or not the anticipated mitigation of the policy, which can only be discretionary bursaries and matters of that kind, are ever going to be capable, as a general proposition, for filling that gap. And the nearer you get to £5,500 per student, or £4,500 per student, the more implausible it seems that that is going to be routinely found from hardship funds, etc. Those are the facts that the minister has to confront. If the minister says, yep, I know the gap's 4,500, it's going to be more, by the way, for someone like Mr. Case, who has LCWRA, because that is not modelled in the scenarios. That's the gap. This is what I know about the general pot of discretionary funding. I think you're going to access some or all of that shortfall to a sufficient extent that I'm satisfied the impact on you is justified. But that's not what the decision does. It's not done because the minister hasn't got in any of the relevant information.
The seems to be two strands. Have I understood it correctly? One is the general, forget existing claimants now, people who are going to be caught by this policy. Do we know how many they are? Do we know how difficult it's going to be? That's one thing. Then there's a second thing which you keep going back to, which is the existing claimants. And there you're focusing on one thing. Oh, look, they wanted to help them get into education because they'll have better prospects for better work with higher salaries and so on. But it does say, given that they are already in the benefit system, and whether one agrees with it or not, the assumption appears to be that if they've already got it, if they've planned their life around the basis of their universal credit and want to go to university, the government appears that to take the view it's even harder to take that which they have not than it is not to give to those who have not.
Well, it doesn't even confront the perverse incentive that all of this creates, which is to defer your education until such point in time.
Yeah, but don't go off on a tangent. Answer the question with the very greatest respect. If you introduce new points. Anyway, I think
you
I've got
agree
the
with that
solution.
point.
Yeah, you do. There are two strands to your argument, yeah.
Yes.
Yeah.
Along with the strand of investigation, as we've clearly explained in our skeleton argument, the fact that there was no consultation is relevant to the PSED.
Yeah.
The fact that the policy had been operated from 2013 or 2017 onwards is relevant to the discharge of the PSED. The fact that none of the data was got in, and effectively, all of this really is, stand back and let's be honest about it. This is a classic Moses LJ rearguard action. It's an EIA conducted at breakneck speed in relation to a policy that's been operated for 4 or 5 years, in which time there was ample time to do the job properly and gather at least some of the data I've identified, and that's never happened.
That raises a question I was going to ask Ms. Clement, but since you've raised it, I'll ask you as well. Does the perceived urgency, in general terms, is perceived urgency relevant to the amount of information you are required to have not to break the PSED? And secondly, if the urgency is your own fault because you've just ignored everything for 3 years.
And my answer as yesterday is yes, urgency may be relevant, but no, it won't be relevant when you are the author of the situation.
Of the urgency, because you've just ignored tribunal decisions and so on. Yeah.
You've ignored the tribunal decision, you've assessed your policy options in 2017, that paragraph 32 of Ms. Garrett's, no attempt to conduct an EIA at that juncture, the options you're looking at that juncture, no attempt to gather evidence, no attempt to get materials from the DFE, nor from universities, nor from local authorities about the amounts of grants, etc., handed out. Literally,
Well, it would drive a coach and horses through the PSED if you could rely on your own inaction and then claim urgency required you to act and not to do.
Correct.
Yeah.
And I suspect, as a man preoccupied with urgency and its use and abuse, if I'd had my way, we might have even challenged the decision in relation to urgency itself.
But on appeal, you're not there.
But no, but we're not. But it is,
Yes.
nevertheless.
You say it's relevant.
Direct relevance.
Urgency could be relevant, but not when it's in effect self-induced, if you're responsible for it. And
Absolutely.
on any analysis, when she got Badu, she must have realised there's a problem here, and sticking your head in the sand and pretending you're an ostrich is, you say, not a factor that justifies you then saying, when you finally take your head out of the sand,
Yes,
oh,
and to
goodness,
take
it's awful.
and to take some steps at that stage to work out roughly, even roughly, as an order of magnitude, how many people are in the different boxes. The boxes are existing claimants, refused new claimants, and suppressed new claimants. They clearly think that there's a large number of suppressed new claimants. Remember the stuff about the fear of the influx of claims. And then the modelling that was done for the SSAC, which is not provided to the Secretary of State. And of course, Bracking emphasises this is for the decision maker personally to be done. So the very fact that 2 weeks later, after the breakneck requirements to introduce the statutory instrument had been dissipated, they could produce the numbers that they produced the SSAC, shows the effect of self-induced frustration, to be honest.
The numbers only go to the amounts, don't they? They don't go to the numbers of students.
Correct.
Yeah.
Correct. So we say that this is standing back, this is a worse case than Bracking. Bracking was a case where the Secretary of State at least had the benefit of the consultation, a mass of evidence in relation to the consultation, and the complaint was that insufficiently careful attention had been paid to whether or not there was hard evidence. This is a case where there is no consultation, no efforts made at all to get in data in a period of time when they should be getting it in, and there is in fact no evidence. I go back to the point I made to the Lady Justice Simler, which is what you have is effectively analysis of what will happen if the rule bites upon you, effectively legal analysis. That's not evidence about the impact that will be had that goes to either the first or second limb of that which you must have due consideration for, or due regard for, under the PSED. And in particular, and this is striking, notwithstanding the fact that the Disability Rights UK letter in 2017 says, here's how disabled people are disadvantaged by a factor of 2 to 1 in terms of their access to tertiary education. Even that data isn't put before the Secretary of State. The Secretary of State is not told we're making an extant problem of disadvantage worse by imposing a further restriction. And you can be certain that that point would have attracted itself both to Lord Justice McComb and indeed Lord Justice Elias, because it's exactly the kind of point that Lord Justice Elias on his approach would have required to have been spelt out for confrontation. And you have to be explicit about the fact that this is making an already deplorable situation markedly worse. So that's PSED. You'll be pleased to hear I'm on track because I had proposed to leave 15 minutes for each of my 2 remaining rationality grounds, not least to control the flack that I anticipate that's coming on the third one. Grounds 2, navigating the thicket. We can take this point relatively swiftly. We've addressed it at paragraphs 39 to 46, bar skeleton argument, page 13 to 15 of the core bundle. The point is ultimately a short one. If the objective of the restriction is not to bar new claimants from obtaining a WCA altogether, but only to bar them by doing so by the most obvious and simplest route, namely an assessment under the provisions of the 2013 regulations themselves, what is the point or justification for this policy? We are all agreed that there is, and always has been, a workaround. And that workaround, I mentioned yesterday, has been known to exist in the teeth of the unlawful policy since 2017. Indeed, if you look at Mr. Royston's supplementary note that was filed right at the end of right at the end of materials, it's page 309 of the supplementary bundle. In response to a question from the judge about what was known about the workaround and when, Mr. Royston put before the court paragraphs 3 and 4 and the relevant bulletins from CPAC.
But it's in the submission.
Yeah. It
One thing we know she knew.
The point is it contextualises, my lord, what's in the submission. Because what the submission at paragraph 14, which you reminded me to read to you yesterday, what paragraph 14 does is effectively summarise what's already going on and being advertised by the department's main interlocutor, adversary, counterpoint, the Child Poverty Action Group, as a workaround for all of this, and has been advertised as much since its Welfare Rights Bulletin 261 on the 1st of December 2017. So paragraph 14 of the submission is speaking to a well-known, well-oiled and well-used, at least by those who are well-advised, workaround.
What's wrong with paragraph 29 of Mr. Justice Swift's judgment? Because that's where he addresses this. He sets out paragraph 14 and he sets out why he thinks it's not irrational for the Secretary of State to say, well, we'll do this because that's what we want to do and that's what we thought the regulations should have said. We know there's another possible route. We're keeping that under review and decide what to do about that next. Why do you have to do everything straight away?
Of course I'm going to address paragraph 29.
Right.
His reasoning comes down to it had to be done because of the need for speed. That's point one. And paragraph 27 and 28 is all about the need for great speed. To which my answer is no, there wasn't any need for great speed. Not least
Because it was self-induced.
well, A, self-induced, and B, the position, the lawfulness of the policy, unlawfulness was clear from Badu onwards.
He says it's self-induced.
Yeah,
He does say it's self-induced.
Yeah.
But then if it's self-induced, there is no need for speed. But
It doesn't quite
Not sure.
well, other than as a result of your own fault. And the second answer he gives is that it's all been kept under review. And we know what the product of that review is. 1 year later, the workaround is shut down.
Yeah.
Nothing's changed in the interim.
So what is irrational not to shut it down straight away? She was too generous by letting it stay for a year. She should have guillotined everything.
That's
straight
the
away.
only approach that
She
was
got herself into a terrible tiz, and she says, gosh, I've got to change the regulations. She should have immediately gone further and said, I can only do one thing. I either cut everything now, or I don't. What I can't do is deal with the most obvious problem and at least pause to see where I go next. She's not allowed to do that.
Well, it's created
irrational.
it's created a system where the consequence of that is that water will flow downhill and people will be driven into using the ESA NIC's route. And that route produces, and will in each case produce, utterly arbitrary results. Why? Because the entitlements that you will get will be dependent upon the administrative efficiency of the department. You'll have to get through the ESA route and your LCW determination before you can make a claim for a benefit. If it takes 2 weeks, you lose out on 2 weeks UC. If it takes 2 years, you miss out on 2 years. And that's the inevitable consequence, and it generates arbitrariness.
So you say it's better not to allow people to do that, not to give them
You
that
can't
option.
defend the rationality of a system by reference to the fact that the users of the system will be driven into a route to entitlement that generates arbitrariness.
But can you not say, as the judge found, she's got herself into a terrible tiz. She should never be here in the first place. She's now finally been brought to a situation where she realises Regulation 14 is defective and she wants to correct it. She knows that behind Regulation 14 there's still another problem, and instead of saying, I'll cut everything off immediately, which apparently would be rational, she says, well, I'm going to do it in stages. Does mean there are going to be some problems, and whilst we keep it under review, does mean some people will get it, does mean there's going to be potentially awkward workouts, but at the end of the day, I'm going to do it in stages. I'm going to wait and see, as you'd like Secretary of State to do, wait and see how big the problem is, what the problem is, and then take steps. And she did it within a year. It's the irrationality of doing one thing now, but leaving a loophole open.
But it's not just a loophole. It's a loophole that everyone
Don't pick me up on language. You know what
A
I mean.
loophole that has arbitrary effects, is
I wasn't
what you're
seeking
saying. Yes.
Honestly, my lord, I really wasn't seeking to make any pejorative comment. It's a route. Let's use the word route. It's a route that necessarily anyone well-advised will use.
Yep.
And when they use it, it will generate arbitrary effects.
Yeah. But But the fact that it generates arbitrary results is poor, but doesn't mean she should have shut it down necessarily immediately, or at least that it's irrational not to. That's really my Lord's point.
Well,
Yeah.
with respect, my submission is that it does.
You say
that
it
it's
does.
irrational. The minute you're driving claimants into the arms of a route that generates irrational and arbitrary results, that makes the system as a whole irrational.
Okay.
That's my submission. You're
Yeah.
either with me
So
or
the
against
only
me.
so the only option was she either had to close everything down immediately or nothing immediately. She couldn't do the staged approach. That's it.
Well, there were many options. She could have left the ESA route open and said that if you establish an entitlement through ESA, you could go back to the date of first claim for the benefit. That would eliminate the arbitrariness.
Oh, so she could have changed the workaround.
Absolutely. Absolutely. There's a host of things that could have been done that either respected in whole or amended the workaround, but none of them were done. And what happened was that the minister went eyes wide open into a situation where it was obvious that people would be incentivised to use the workaround, and that would generate arbitrariness. And it is, in my submission, obviously arbitrary and unfair to make your entitlement depend upon the speed with which your case is resolved. Look at the facts of my client's case. In the end, and this answers a point the tribunal made yesterday, in the end, his entitlement to LCW and LCWRA was decided on the papers because the extent and seriousness of his disabilities was so obvious that no even personal meeting or anything was required.
Can I just check as a matter of
Yeah,
fact, without spin, what the arbitrariness is? Is it that it's not backdated, it's just from the date of the determination, the ESA and the crediting of national insurance?
So
That's
claim
the
date
arbitrary.
would have avoided that.
Yes.
So it's the absence, when we talk about arbitrary, it's the absence of backdating to claim date.
Yes, and of course it's important
Sorry,
in that
can I-
context. I'm sorry.
Can I? The absence of backdating is a feature of the other route, the ESA route, which presumably applies in other circumstances as well.
No, it won't apply.
Not
in the-
just, it's a route available to people other than people in the in the applicant situation. So, isn't there might be wider consequences? I mean, you're effectively saying it's not rational to choose anything other than certain alternatives, of which this is one.
Now, to answer that question, my lady, 2 points. The first is that the anchor point of the 2013 regulations for entitlement is the date of claim. And the original regulations, properly construed, work by reference to a date of claim and an assessment that's then conducted thereafter, generating entitlement. That's what's being changed.
Yeah.
And if you had used the ESA route beforehand to get an LCW, you'd have still benefited with a claim back to your date of claim.
Oh.
So under the 2017 situation prevailing when CPAG gave their advice, if you'd gone down the ESA route to get an LCW, a WCA leading to LCW, that would have generated an entitlement that went back to the date of claim under the old regulations.
What I'm missing at the moment then is why it's not being backdated to the date of claim now. I just don't understand the legal mechanism as to why it is. I'm trying to understand what the arbitrariness is, and you've told me, and I've written down, the absence of backdating to claim date is the arbitrariness. I've written that down. What I don't understand is how that arises from the regulations at the moment.
It arises from the differential wording of Regulation 14B and 14.1b. One goes back to the regulations and one looks at the original regulations.
But we're using the workaround now. We're in a world where...
But the workaround is just a workaround
to get a
to get
determination.
LCW.
Yes.
And the question is then how LCW and that finding works under the regulations.
Yeah.
So if you go back to the original regulations, that's in the authority bundle, tab 8, page 97.
Yeah.
Three substantive criteria, or two substantive criteria. You have one of the three benefits, and you have LCW.
Yeah.
If you, after making the claim, establish that you have LCW through the route, the ESA route, that will, under the original regulations, entitle you to the benefit from the date of your claim.
Why?
Where do we get that?
Show me the words on the paper that
Why?
say that.
Because applying the approach of Judge Pointer in Badu, the proper approach to the regulations is that once a claim is made, you have to conduct the relevant assessments in question. If the assessment in question is conducted not via the route of regulations 40 and 41, as was the case in Badu, but is conducted instead by a rival mode of assessment under ESA, to which regulations 40 and 41 cross-refer, if you remember. Regulations 40 and 41 say you can prove this either by an assessment under these regulations or under the ESA regulations. At that point, after your claim, your LCW has been assessed not under the 2013 regulations, but under the ESA regulations, at which point your claim is accepted from the date it was made.
Why isn't that the same for every ESA claim then?
Because under the scheme of the new regulations, in order to make a claim,
So we're now back in tab 7.
Yeah.
correct, lady,
57.
you're in tab 7, page 57,
Yeah.
you have to have the determination of LCW in your hand at the point that you make the claim. That's the
So
difference.
you're saying even though the ESA route is merely a mechanism to get the LCW assessment, and then you have to make a claim.
Correct. And the effect of the drafting changes is to affect the impact or effect of the ESA assessment just as much as the
Okay.
impossibility of...
Because you can actually only make your claim
Once
after
you've
you've
got
gone
the
through.
Correct.
No, I know.
And that's what generates the arbitrariness.
I'm still not quite sure I've got it, I'm afraid, from 14b, looking at the words. The person is entitled to attendance allowance, disability living allowance, or personal independence payment, and it has been determined that the person
It's
is
that
limited...
word. It has been
Yes.
determined.
That the person is limited capability for work or limited capability for work on the basis of an assessment in Part 5. So that's the thing that limits it to...
It's that wording has been determined, and then after the Roman 1 to 3 list, and that
that
determination
determination.
was made on or before the date
Okay.
of claim.
I think the thing I was missing at least is that you can't make your claim under the revised route, even via the ESA route, even if you've got the LCW via the ESA route, until you've got it. Then you file your claim, then there's presumably a further period and still some backdating, but only to that later claim date.
That's correct, my lady.
So
So
this...
it's the key point is that the regulations change both the original route to entitlement, the Badu route,
Yes,
and
exactly.
they modify the ESA route to entitlement.
Yes, that's what I was going to ask, because they have done something about the ESA route. It's not just they've left it there and reviewed it. They've actually modified it from what you're now saying in the
Correct.
14.1b, and I now understand it, is that they've introduced the arbitrariness of the backdating.
Correct. That's the point. And that point is nowhere confronted in paragraph 14 of the submission to Minister. And it's nowhere been answered. There's never been any explanation to that arbitrariness beyond reference to Pantellerisco. Now, my Lady Justice Simler will remember that case well. When my learned friend takes you to the Secretary of State's favourite passage, there are always cases with favourite passages, and the current favourite for the DWP is paragraph 90 of Pantellerisco. When she takes you to that passage, I hope she also takes you, and if she doesn't, I'll jump up, to paragraph 89, which precedes it, which makes the point very clearly that this was not, in the facts of Pantellerisco, a vagary of the workings of the system that was well understood at the time that the decision was made. We're in a fundamentally different situation. The Secretary of State has been shot full-blown between the eyes by CPAG and knows exactly what the workaround
Can we just tone the language down to fact and law and look at 14b again, because I'm having real trouble with this. Because every time you solve one problem for me, and it's my problem and I apologise, I see another one. I thought simply that the workaround was this problem. Before I looked at the regulations, even if they don't get their determination of LCW before they start university or before they make a claim, they're in trouble. But if they haven't got their determination of LCW before they go to university, don't worry. They start university on the 10th of October. In November, they go and get ESA, and they'll be all right. If they haven't got NI credits, they'll be credited with NI. And I thought that's how it worked. But from what you've just told me, unless I've misunderstood what you've told me, the determination of ESA also has to be made before the date of the claim or the date that they start university education. So I'm now puzzling how ESA can ever be a workaround.
No, it has to be made before the claim.
The claim.
not before you
It's only the
start the
2021 regulations.
It says,
that
and that's
then say-
made on or before the date of the claim, where the person is receiving education that is made, or the date on which the person starts receiving education, where the person starts receiving education after the date of the claim.
But
So how can I
So if you're in education, you can get your LCW via the ESA route and then put in a claim.
Correct.
yeah.
so long as you do it before the universal credit claim.
Correct.
Gosh, and that's what 14B means.
Yes. That's why my client has received belatedly the benefit.
No, I know he's got it. I'm just trying to understand the words of the page. It's my fault because I mean I do law normally, but this is impenetrable.
This isn't just law. This is social security.
And just to be clear, the closing words of B are what helps the existing
Absolutely, my lady.
claimant.
Yes. And it's that is then shut off by the 2021 regulations, which aren't under challenge, my lord, but nevertheless produce a useful illustration of how you would shut the bolt hole altogether. That's page 106. And it's just a simple, you must have had the assessment before you start education.
So no more workaround.
I'm sorry, I know my colleagues have got it, but I really haven't got it. And can you just have one last go? I'm really sorry about this. And that determination includes an assessment that you qualify for ESA.
It does.
Right? So that determination that you qualify for ESA must have been made before the date of the claim. So you don't put in your claim,
Yes.
you go for ESA instead.
Yes.
Or if you put in a claim and it's closed, you go for ESA instead, and you make a new claim or your first claim after you got the ESA.
Yes.
And that's why the arbitrary arises, because it's only backdated to the date of the new claim. If you
That's
like.
right. And
Right, I've got it now.
The reason why, let me just...
By gosh, I think he's got it.
It's
Yes.
Roman 1, my lord.
Yeah.
It's Roman 1.
Yeah.
Because Part 5 is Regulations 40 to 41, which is what was at issue in Badu. That's assessment under these regulations. And Part 4 or 5 of the ESA regulations are the equivalent provisions leading to an LCW assessment under the ESA regulation. And so it doesn't matter which of the two routes you go down, you have to have had that determination made.
Before you can make a claim that's going to be effective, yeah. But the other point then is that she has done something about the ESA route in these regulations. It's not just as I thought, and perhaps Mr. Justice thought, this was in the system. It's in the system, but tweaked
Yes.
by these regulations.
But you say tweak to produce arbitrary and adverse results, not to improve the position.
Absolutely.
Yes.
And for the reasons we've set out in our skeleton, it then turns the extent of your claim into a function of how expeditiously it's dealt with.
But what's irrational then? 14B1 or 14 the amendment?
What's irrational is continuing to accept that an ESA route is a route to establishing LCW, even though you're closing the route to assessment under Part 5, but then saying you're only going to get that benefit from the date of the assessment being completed. That's the first point at which you can make the claim. It's tying your entitlement to the speed with which the department handles your ESA claim.
Then is 14B, is the change to 14.1b that's unlawful. It's a much narrower thing, isn't it?
But your challenge is much broader to the regulations. Your challenge isn't simply that the ESA route should have allowed a backdating.
Our challenge is that the end product of this rule applied to shut the extant route to assessment under Part 5 and to modify the ESA route generates a system whose outputs will be irrational. They'll be arbitrary, because what it will do is push anyone who's well advised to use the ESA route, at which point they get benefit linked not to their need, for the full period of study, but to the speed at which their claims are assessed. Or it creates a thicket, and if the thicket is one that troubles the Court of Appeal to the extent it obviously has for the last 20 minutes, God help any applicant who doesn't have CPAG on their side, whose thicket is resulting in people simply giving up the ghost and not pursuing their entitlements. It's either arbitrary results or a system that is so impenetrable to any ordinary human being that no one makes a claim. And that's not a
Trying to
proper basis.
focus, we can put a line through things. I mean, there's lots of cases saying you don't strike down things more than you need to. And I'm still wondering whether the real problem now is including the modification of the ESA route in 14.1b. I know you want to say the whole thing is irrational, but just think of the awful consequence if we didn't accept that argument, and there might be a lesser argument that at least part of it is unlawful. Can you take out 14.1b on its own? And if you took out 14.1b, what would be the consequence? You get an ESA...
Well, that's where we are now.
No, the consequence is if this argument's accepted, that the modification to 14.1b is ultra vires, at which point we would revert to the previous regime. And the previous operative regime...
You get your ESA anyway, because you get credited with national insurance.
Correct.
Yes. You can't separate it out then.
You can't. There's no severance possible because the ESA provision appears in Roman B1 alongside the Part 5 appearance. So the only conclusion, we haven't talked about relief, I don't want to get ahead of myself, I think that would be extremely rash. But were the matter to be found to be ultra-virus, we just revert to the previous regulations. Many illustrations of that. The recent Ofcom ALF's judicial review, exactly that.
So you see, paragraph 29 is wrong. I hadn't appreciated it because you see the judge is wrong because it's not a wait and see approach. It's do something that you say leads to arbitrary consequences by modifying the ESA date and then wait and see.
Correct. Anyway, I am running after a little bit behind. I have had a few questions. I hope
You have.
forgive me.
You have.
I think I've mined that one as far as I can. That takes me on to ground 4, and I was ground 3 rather, my fourth point that I'm opening, and I was planning to spend about 15 minutes on it.
Well, you can have your 15 minutes
I'm
because
grateful.
we have asked you a lot of questions.
I'm grateful for it. Our case here is very simple with respect. It's simple and hard. Let me be honest. I mentioned Cruz and Johnson and Matadine and Pointu, and I put those authorities on your desk.
Yes, thank you.
I rather anticipated that's what you wanted me to do, having referred to them yesterday. The relevant passage in Cruz, it's summarised in the head note. In determining the validity of bylaws, and the approach applies equally to delegated legislation, a bylaw ought to be supported unless it's manifestly partial and unequal in its operation between different classes, or unjust or made in bad faith. And it's the unequal in its operation between different classes, which was simply by reference to different groups of people, not protected characteristics or anything of that kind. The relevant analysis is the speech of Lord Russell, starting at 99 in the last paragraph, what are the checks, culminating in the passage that spans the page at the bottom of 99 through to 100. That is, I think, part of the common law ethos that Lord Hoffman then draws upon in Matadine in Pointu. Yep. And I am not going to do what people often do, which is point you to the familiar quotation about it's the general axiom of rational behaviour, etc., without pointing you to the very extensive passage that comes thereafter at page 109, because Lord Hoffman goes on to ram home, and it's very much on message at the moment in recent Supreme Court and indeed decisions of this case, that exercise is primarily a political one.
Yep.
And it's an exercise in which the court should pay very substantial deference to the decisions of the Secretary of State. He or she is democratically accountable, has resources that the court doesn't have, etc., etc. It is all of that that then informs the swathe of cases my learned friend relies upon to say that the standard of unreasonableness in relation to a statutory instrument is somehow supercharged. There's been lots of toing and froing over adjectival description of that proposition. Most of it, I think, unhelpful, or often at risk of dancing on the heads of a pin. It is a very high hurdle, and we accept and embrace that. But that is the basis for the challenge in straightforward common law rationality.
Yeah.
It avoids interesting but perhaps unnecessary argument about flemenos and protected statuses under the convention and so on and so forth. Now, against that hurdle, the first thing to note is the perverse incentive that's created, at least in relation to those individuals who aren't aware of the workaround. The perverse incentive that this policy creates is to delay your education until you have your benefits, thereby putting off the benefit that the Secretary of State generally wishes to support, which is that disabled people should be assisted to obtain new qualifications and skills to better help them access the job market. The second thing to note is that once the rationale that supports the continuation of entitlement on the part of existing claimants is identified, the key question to ask is why that rationale does not apply with identical vigour to the new claimants. The predicate of the rationale in relation to existing claimants is that but for continuation of benefit, they would be deterred from entering university education. Why? Because if they had to choose between the certainty of their current income and the uncertainty of receiving charity or discretionary payments, DSA being a wash, there's a good risk that they would choose not to enter education at all.
But aren't they in a different position? If you've got the money and you'd lose it, you're in a different position from somebody who hasn't got the money but has a choice to apply to not go into tertiary education, apply for universal credit, get your determination, and do make whatever choice you wish, or to do it knowing that you'll have to make up the shortfall, and that may be difficult. Aren't they in a different position?
They're in a different position only to the extent that they are already receiving support.
Yes, but that does make a difference, doesn't it?
It makes a difference because it makes more concrete, I accept, in terms of what's in your head, what the consequences of accepting education will be. It is, I'm currently getting this much benefit. If I've got a calculator and I can work my way through the calculus in Regulations 69 and 70, perhaps with the assistance of CPAG, or I can work out what the consequence of my receipt of my particular maintenance will be on the amount of universal credit I receive. And I can make a decision as to what the consequences will be if that money were to be taken away altogether.
Yeah.
That's the difference. But in terms of the underlying need of the relevant parties, it is no different. This is a cohort of people who by definition have LCW, or indeed by definition have LCWRA, an enhancement payment to reflect their particular disabilities. And the key question for people in both cohorts is the same. Can I go to the university I wish to go to, away from home if that's where the course is, and afford to live? Will I be able to generate funds? Will I be able to feed myself healthily? Or will I have to eat into my PIP and give up on physiotherapy or whatever the particular treatment I have to pay for as my PIP is in order to fund my studies? And that is the same question, the same sort of deterrent effect that confronts in both circumstances. But one cohort of claimants, those who are already in receipt of universal credit, are told you'll still have an entitlement, albeit it will be reduced. And another cohort is said, effectively, you must fend for yourself and choose whether or not you wish to accept the consequences that the state will support you, not one jot beyond DSA, which everyone gets, and thereafter you'll have to apply for discretionary funding.
The starting point, of course, is that the Act assumes that you're not going to be getting universal credit if you're in full-time education. Parliament has decided that there's a difference between the two, and there are exceptions. And the thing is, they've said one of the exceptions is going to be those people who've already got a certain level of income, and regulations don't want them to suffer if they take that away. So if you put it in its broader context, doesn't that also affect matters?
Well, in its broader still context, the exceptions are themselves in categories of very long-standing, and they're unified by a theme that they're all categories of people who, for whatever reason, can't be expected fully to support the needs of themselves or their family group and go to education. And that's why the exceptions are for, first of all, young people who are effectively alienated from their family and therefore can't expect the family support everyone else is required to receive.
Yeah.
Or people with young children or foster children in their care who have limited ability to study and work and care for their children. So the unifying thesis behind all of the exceptions in made in the regulations pursuant to 4.2, so in regulation 14.1b to e, is that they are people who can't be expected to supplement their income through work, and therefore an exception should be made for them. And that's the starting point for disability. The disability exception has been tightened by removing the presumption of LCW that effectively operated previously and saying you have to substantiate it. So be it. But then it's just getting more granular about showing that the person in question can't be expected to supplement their income through work. But that is still basically the same system. And the arbitrariness is that within that cohort of people who can't be expected to work to supplement maintenance grants, etc., and other forms of assistance, quite arbitrarily, depending upon whether or not you've already accessed the benefit system or not, this line is drawn. And it is arbitrary at the end of the day. And you can test its arbitrariness by saying, what's to stop me deferring for a year or 2 years or how long it takes? Nothing. It's not a distinction of any substance at all. It's not geared to the factual circumstances of the individuals. It's not geared to their needs. It's just geared to the fact that they wish to go to university straight away from school. And of course that leads to the effect, actually, that the consequence of disadvantaging young people, immediate school leavers, is that they are deracinated if they put off from their friends and from the usual path of passage into university with their cohort of friends from school, etc. They must put off their studies, and effectively they have the choice of mature studentry thrust upon them.
So really there are three, if you disentangle the submissions, there are three states of mind to address in terms of rationality. One, a system that's based on recognition of those who can't supplement their income through work get treated differently, and these are disabled students who are in the same. That's one category. Secondly, there's perversity arising from the fact that they can get around it easily, but just waiting a year and getting universal credit and then going. And the third is, you say, the underlying rationale of the existing claimant group, but you sense a certain resistance to that because you've got the
resistance to pretty much all of it.
no, to the fact they've already got it. But you would say your first 2 points, the recognition that if people can't get supplements for their income through work, should be carried through logically to another group who are in the same position, and particularly when it's so easy to avoid, as you say. And you could say that without existing claimants at all.
The very logic of the exception made for existing claimants negates the whole reasoning for the disapplication of the benefit to the new claimants. It's completely contradictory.
You don't really need the existing claimants, although you say it helps.
Well, it provides my comparator. It provides my class of people in Cruz and Johnson's sense who are receiving manifestly different and arbitrarily different treatment.
But you would say it would still be irrational, although not differential treatment. Well, why isn't it differential treatment for your first strand, the people who do get the income supplemented because of other factors, as compared with disabled students who don't? Because they would be different classes with the same need.
Yes, but they're different classes of disabled people. It's a discrimination. It's between a cohort of disabled people based upon whether and when their assessment of their needs is
and you couldn't rely on it for Article 14 purposes because the very criterion that differentiates them is the
thing. Hence why I'm arguing the case on the
but you can rely on it under common law.
That's why I put the case
fair.
of common law. You grumbled me. What do we say? Well, we say this. There's obviously substantial detrimental treatment. You've got the scenarios that show the difference in payments in question, and it is a very appreciable sum in the context of student funding. And against the backdrop, let's not forget that the student in question has to repay the maintenance loan. If you're going to tough your way through it, there's a very good chance that what you're going to actually have to do is incur yet more debt if anyone will lend to you. That's the first one.
Well, it would arise, really, I don't see somebody else who wasn't a student, but it doesn't arise because it's the limited capacity for work that's the problem. That's the real difficulty.
That is the problem, and we've always said that that's the
Yeah.
problem. The second problem is that the forms of statutory assistance to which you've been pointed don't answer the issue. DSA is dealt with by Mr. Butler's evidence, paragraphs 20 to 21, page 51 to 52. It's very rarely paid as a cash payment. It's rather paid to reimburse the person providing you with the things that you need to study. And it's not designed and not paid to, not set at a level to meet your living needs. It's designed to give you adapted computers or matters of that kind. And it is available to both existing claimants and new claimants. And it is not taken into account as income under the scheme of the regulations. Why? Because UC is about helping you meet your living costs, not these types of exceptional costs. So it is, as I say, a wash. And yet the EIA, in the critical second paragraph dealing with disability, refers to the student support system, and then under the evidence and analysis section refers to DSA. It's completely irrelevant. So too is maintenance, and that has been referred to in the justification. You're expected to go down the maintenance route. And the answer is that given by my Lord Justice Lewis, which is maintenance is not expected to meet the entirety of your needs. Maintenance combined with work is the expectation of most students. Work and to an extent support from family. And the critical difference is...
Is there anything in the rules, the regulations, or the departmental material to say that the maintenance levels are fixed deliberately, not to cover everything because they want them to study and work? Or is it just that we think they're going to be having to work because their lifestyle is going to involve going above the maintenance level?
I think the correct answer, Mr. Royston will prod me if I get this wrong. I think the correct answer is that there are two tells on that front. The first is that the level of maintenance you get is affected by your family income.
Yes.
That's point one. But point two, the payments made of universal credit are set by reference to the out-of-term periods. In other words, they take into account your maintenance in the periods that you're meant to be at university studying, and they set your entitlement differently. That's correct, isn't it? For the long vacation. So in the summer, the long summer break, when many students can and do obtain more substantial work, the level of entitlement goes down.
So the maintenance is linked, still unclear to me, it's linked to your term time needs, but it's meant to cover those term time needs, bearing in mind that if you've got wealthier parents, it'll be adjusted accordingly because we come from there.
Or the ability to work.
Correct.
But no, the ability to work isn't built into it. The maintenance loan is fixed for the term time period. The maintenance loan
Only by the support from the parents.
Yes.
Yeah, okay,
But you're saying the assumption is that during the vacation they're going to work. But if you're a disabled student and you can't work, isn't the assumption then going to be you go back with your family, or is there going to be a separate subgroup of people who can't go back to their family,
Well, I think they're
can't
addressed.
work, and so on? I mean, are they not dealt with?
They're addressed, I think, to the extent that they are addressed by 14.
This is the young people
Yes,
alienation.
14.1a, page 57.
Yeah.
If you're a person who's undertaking a full-time course, you're under the age of 21, or you've reached that age during the course,
And it's without
and you are without parental support.
Okay, so that's taken care of then, in effect. If you're a student, you'll have to go and live with your parents in the vacations, and the maintenance loan is not intended to you, then if you haven't got it, you'll get it. and during term time, the maintenance loan is fixed at a level that's necessary to meet your needs. But of course, if you've got wealthy parents,
But
it's
even then,
lower. So it's
the
not quite
practical-
right to say the maintenance loan is fixed by the department at a level which presupposes that you're going to have to work
Well,
during term time.
even then, I think the practical reality.
That's different. I'm asking. I did
Yeah,
say
no.
that in the regulations of the departmental material rather than the real world.
Well,
I made it clear.
I will consult with
Yeah,
Mr.
okay.
Royston,
Yeah.
the
But
oracle.
that seems to be the
of lunch, and
position
see if I
that
can get a
we
better-
can't say from the moment that we've got material in front of us that shows that the maintenance levels have been fixed specifically with an assumption that you'll be working during the term time.
The materials do address the long vacation point,
Yeah.
not my
But
lord.
long vacation is different. I accept that.
Yeah. So then we come on to the point that there's no ability to replace through earnings. It's not clear what the judge thought in relation to this, because that point was only addressed in the passage of his judgment dealing with the PSED, where he referred to the highly speculative nature of any inability to work. Insofar as that's a consideration, it's not highly speculative. It's by definition,
Limited
because you have
capacity to work.
LCW. So that's a bad reason. And that then just leaves discretionary bursaries and the like as the only source of a route out of this. And effectively, it's a kind of Hail Mary argument. Someone will provide. But it's quite irrational to apply that in circumstances where the someone will provide argument is not applied to existing claimants and yet is to new claimants. And it's particularly irrational to do so, and here matters link directly to the PSED, if you haven't even investigated what it is that someone might provide and whether or not someone is providing something and to what sort of level. In other words, you haven't investigated what sort of bursary payments new claimants are in fact receiving, if they're receiving anything at all.
So just to be absolutely clear that I'm understanding what you're saying, the whole of this ground really does depend upon a comparison between the existing claimants and the new claimants.
Yes.
It's dependent on that.
Utterly.
Yeah. Just so that I've got it clear, I don't get lost in the thicket. It is dependent on that.
Entirely. It is a Cruz and Johnson unequal treatment of different classes of case. Class 1 is new claimants, Class 2
Yeah.
is existing claimants. And it's basically the Secretary of State not accepting the inexorable logic of what's applied to existing claimants as applied to new claimants.
Yeah, that's it.
That's the argument. It's either good or bad, and it's got to meet the high threshold in question. Unless there's anything else I can assist you with, I'm sorry I've taken so long.
No, I'm clear.
Thank you very much, Mr. Delamere. Yes, Miss Clements.
Milady, can I just have a moment to rearrange
Yes.
everything? To lift the laptop up so I can actually see it. Milady, in terms of how I intend to structure my submissions, first I want to make a few additional points about the statutory framework. I'm not going to repeat what my learned friend has said, but some additional points that I'd like to draw the court's attention to. Second, I would like to highlight some key points from the evidence that was before the judge. And we've not spent a great deal of time looking at the Secretary of State's evidence. That does have to be borne in mind that the challenge now advanced before this court is significantly different to the way the case was advanced below. The fundamental point of the argument below was that what the Secretary of State says was her policy was not, in fact, her policy. And a great deal of the evidence was directed to that submission. Obviously, that is not something that this court now has to grapple with, because my learned friend quite properly accepts that he cannot challenge that evidence and he cannot challenge the findings made by the judge. And then third on my list is to make submissions on the 4 grounds of appeal. Now, on the statutory framework, I'm afraid I do have some additional provisions to hand out. I do apologise for that. My learned friends have these already. It's a small additional bundle. Can I just hand those out?
Our authorities bundle might burst.
It's got a
Did
separate
you-
index. It's got a separate index on the front. So perhaps if it's just left as a standalone document. But my lady, while those are being handed out, before I come to those, I'd like to direct the court's attention, please, to section 8 of the Welfare Reform Act, which is at tab 4, page 31. This is the main bundle, not the supplementary. And this simply goes to the point.
Tab 3 or tab 4?
Tab 4, my lady.
Okay.
Tab 3 is the Welfare Reform Act 2007.
Yeah,
Tab
section
4 is the same title but 2012, just to keep us on our toes.
Yep.
So tab 4, page 31.
Yep.
My lady, I'm just inviting the court to look at this, that section 8 is at page 39 within that tab.
Yep.
Because my learned friend says, as part of the PSED, or as part of the rationality analysis, the Secretary of State had to know what the difference would be if students got universal credit if they didn't. And I just want to show the court the calculation of awards and how universal credit awards are calculated.
Yeah.
So, the lady, one sees at section 8, the amount of an award of universal credit is the balance of the maximum amount. So one can know what the maximum amount is, but then at less the amount to be deducted. So one sees at section 8.2 the maximum amounts include the standard allowance, and B is not relevant, C is housing costs, that was going to depend on what the actual housing costs are, and D is any amount included under section 12, that's the LCWRA element. But then underneath that, subsection 3, one sees the amount to be deducted, and that is an amount in respect of earned income calculated in the prescribed manner, and then an amount in respect of unearned income calculated in the prescribed manner. And I'll show the court the regulations on this in a moment. But essentially, the answer is it all depends on the facts. What one may or may not have got by way of universal credit is not a figure that one can say to the Secretary of State, any disabled student eligible for universal credit would have got X amount.
Can I just ask, is the standard allowance, I look quickly at section 9, we can see housing costs and children costs. Is the standard allowance, am I going to find somewhere, if I ever get to it, something that says this is what we expect a young person to have in order to be able to eat, dress, and live?
My Lord, I thought your Lordship might have that question. In the supplementary authorities, tab 4, this includes some additional elements from the universal credit regulations at the time, and I have a bundle that has internal pagination 33 on the bottom corner.
Yep.
That is the table showing the amounts of the elements at the relevant time.
Right.
So one sees, my Lord, the standard allowance for a single claimant under 25 is, for each assessment period, is £256. The LCWRA element is 341.
But essentially, it's the amount that you need to live. If you're under 25, you need £260 a week to live. And if you've got housing costs as well,
that comes on.
you need that. And if you've got 2 children, you've got to feed and dress them.
One
you get
gets
that as
additional
well.
amounts.
So the universal credit is a shorthand for basic housing and living needs.
Basic subsistence levels.
Basic
my Lord,
subsistence,
yes. My Lord, those are the basic sums, but with the deductions and the tapering.
Yes, I know.
For other income. Yeah. I know my Lord Justice Lewis has dealt with these cases before. I think my Lady Justice Simler has as well. But it's not a set amount for each individual. They don't get the same amount of money. It's all an individually tailored exercise depending on initial subsistence needs and deductions taking into account other sources of income available to individuals. And I'll show the court that when we look at, there's particular provisions in the Universal Credit Regulations that deal with the treatment of various elements of student support, so the maintenance loan and various additional grants. And there are also deductions in there for earned income because many disabled students do work.
Yeah.
So if you were somebody who was who had been determined as having a limited capacity for work and you were under 25 going to university, you could expect 25605 per week plus 128.25, subject to whatever other deductions needed
Subject
to
to
be
the
made.
deduction.
But that would
And
be the
that's-
starting point.
Yes, but that's the interaction, and I'll come to this in a moment in the evidence. That's the interaction of the student finance and the universal credit regime. Because the student finance regime is also designed to meet an individual's subsistence levels. So there's no intention throughout any of this that there will be a double recovery element or double payment element, because the student finance regime is supposed to be capable of meeting the subsistence levels of those who are studying.
So there would be deductions to reflect whatever double recovery.
Considerable
was
deductions,
identified.
my
Yeah.
lady, and I can show how that is done when we
Okay.
look at if it's necessary to look at the detail of the regulations.
So in a nutshell, basic subsistence is met if you're a student through maintenance loans, an adult through the standard allowance plus the add-ons for universal credit.
My lord, absolutely.
Yeah.
And the questions that my lord was putting to my learned friend about working and students who work, the setting of the student finance regime is not based on an anticipation or an expectation that students work. Now, they may do in certain circumstances. There are many universities that prevent or prohibit their students from working, certainly during term times, and strongly discourage it during the long vacations. But the setting of the basic subsistence levels for students is not done by reference to an expectation that students will work. It is based, as I will show the court in a moment, on the expectation that parents or families will contribute to the financial needs and the basic subsistence needs of those who are studying. And there's a difference, as I think my Lord Justice Lewis picked up, between what in fact students may do and the legislative policy that sets up the student finance support regime. And I'll come to that, if I may, in a moment. So, my Lord, that dealt with Section 8. Section 37, back to the main bundle, is in page 45. Page 45 of the main bundle. This is the circumstances. We've seen the definition of limited capability for work. So it's not reasonable to require the claimant to work. One sees that to 37.1, but many do, because that's how one takes account of the earned income. And one also sees, my lady, the definition section at 37.8, that regulations may provide for a claimant to be treated as having limited capability for work until it has been determined whether or not that is the case, or the claimant is treated as not having it. And we see the point that I think is common ground between us now. We see there is no provision is made for treating disabled students as having limited capability for work. And that is different, as I will show the court in a moment, from the position under the legacy regime, under income-based employment and support allowance. Now, if I can invite the court to pick up the supplementary bundle again, tab 3.
So your point, there's always got to be an assessment at some stage or a determination.
Yes,
Yeah.
and that was not the case.
Previously, because they were treated as if they had PIPs. Yeah.
The additional point I want to make from the 2012 Act is that we've talked a lot about the regulations that were made, the challenges to the regulations. It's important that the court sees the procedure set out in primary legislation for the making of regulations under the 2012 Act. And that is in tab 3 of the supplementary bundle. There's an interpretation section at the front. I just realised the court didn't have that in case they need it. But section 42 is the regulation making power. So subsection 1, regulations have been made by the Secretary of State, and then it sets out what may be in the regulations. And over the page is the regulation making procedure, section 43. The important point, no duty to consult at all. Subparagraph, does my lord
No,
have
I
that?
don't.
My lord,
In the supplementary bundle, yeah.
supplementary bundle, tab 3,
Yeah, got it now.
right at the back.
Be kind to the elderly.
Thank you,
Yeah.
my lord. 43.1, regulations under this part are to be made by statutory instrument. And subparagraph 2, a statutory instrument containing regulations made by the Secretary under this part is subject to the negative resolution procedure. There are some exceptions to that. We're not in those exceptions. My lady, one then sees 43.6, the definition of negative resolution procedure, which says it's typical meaning, it means negative resolution procedure subject to annulment in pursuance of resolution by the House of Parliament. So one lays it into Parliament, and unless someone annuls it within 40 days, it is a statutory instrument. So, my lady, the only statutory duty to consult is that in the Social Security Administration Act, and that is consultation with the Social Security Advisory Committee, which I'll come on to in a moment. My lady, turning then to the Universal Credit Regulations, the one additional provision that we haven't looked at in the supplementary bundle, tab 4, Regulation 22, right at the start of tab 4. This is the deduction of regulations about the deduction of income. And again, it's making the point I made initially that one doesn't just take the allowances, one then has to deduct all of these provisions, including income through work, which many of these disabled students will have. And then we've seen in the main bundle regulations 68 and onwards that make specific provision for student support. And my lady, one sees that at, it starts at, for your ladyship's note, it starts at page 71 of the main bundle. Person treated as having student income, and then how that is deducted from the allowances that I've just shown before. So how one calculates the amount of the student income and how the deduction is dealt with. My lady, we've then agreed on the point that there's nothing in the regulations that treats disabled students as having limited capability for work, so I'm not going to turn them up to show an absence. That is a common ground. But the important point is that one is not eligible for universal credit under Regulation 14 until it has been determined that the disabled student has limited capability for work. And this addresses the timing or the backdating point that my Lord Justice Lewis is concerned about. And I'll come to that when I look at Regulation 14, if I may. One then sees, if I could invite the court to look at Regulation 14, or the 2020 regulations as made, and that is in tab 9 of the regulations, at page 99. And we see, my lady, they were made on the 3rd of August. That was the next working day after the Cowser concession. That was on a Friday, this was the Monday. They were laid before Parliament the next day, on the 4th of August, and they came into force the day after that. And one sees the confirmation that the regulations were made in the exercise of the powers that I've just shown the court. Yeah. And the important point underneath that looks at the Social Security Administration Act 1992, in accordance with section 1731A, it appears to the Secretary of State that by reason of the urgency of the matter, it's inexpedient to refer the proposals to the Social Security Advisory Committee, and we'll then look at what happened after that. But one then sees Lady, I do apologise for a moment. My computer has decided that is the moment at which it would like to close my Adobe, which means it has closed all of my documents. I'm just going to do a swift swap with my junior and invite her to reopen them on my machine. My lady, but one looks at tab 9. And the amendment at paragraph 2.
Yep.
So what do we then have? The person is entitled to the disability-related benefit, so for these purposes, DLA or PIP, and it has been determined, so it means at the point that one makes the claim, it has been determined, so it has already been determined that the person has limited capability for work. And then at the bottom, and that determination was made on or before the date of claim to UC.
So you've already got your LCW before you make your claim.
At which you make the claim.
Yeah.
Well, what was confusing me, I think, you could have made a claim, but it would have been refused because you hadn't got it. So when they talk about making a claim, it's a cumbersome way of saying don't even bother turning on the computer and going online until you go to LCW.
Yeah.
That's what was bothering me.
Because it will,
this
my lord, it
claimant
will
had
be
actually made a
rejected.
claim before, but it was refused.
Yes, because the eligibility criteria are not met.
Yeah.
So the way it interacts with what we've called the workaround is that one then has to go and get the determination of limited capability for work, and I'll show the court how that works. And then once one has it, one comes back and makes the fresh application for universal credit. And I'll show the court why it wasn't possible to keep the claim open, keep the universal credit claim open, while one goes off, gets the LCW determination, and then says backdate it to the date of my original universal credit claim. This wasn't a point that was raised below, but there is nevertheless some evidence on it, and it will explain. In short, it's because the universal credit IT system is not set up and does not allow a claim to be kept open while that determination is sought.
It's a design flaw, then, is it?
Well, my lord, it sounds very simple, and it sounds as though one could simply say, well, let's fix the design flaw. But it's not a simple question of pressing a button and the Universal Credit IT system can magically change overnight. It is a huge piece of programming.
Yeah.
But Ms. Garrett explains why. That's part of the reason why these changes needed to be implemented as quickly as they were implemented. And I'll take the court to that in a moment, if I may. Sit back. May I just do another...
Gosh.
My lord, of many thanks to my junior for that. So that's the 2020 regulations, and then the court has seen the 2021 regulations where the workaround was closed off. I can turn that up if that would assist, but I think we've already seen it, so I'm not proposing to do so.
Before you leave the amendment, and since we've gone into the ESA, and the penny dropped a short while ago that they modified the ESA, if nothing had been done to modify the ESA, the claims could have been back. The ESA would have meant backdating.
No,
No?
my lord,
Right.
nothing was done to modify the ESA. Perhaps if I'll take matters out of order, let me show you, lordship, how the ESA workaround works.
Yes.
Yeah.
Nothing was done, my fundamental point, nothing was done to amend the Welfare Reform Act 2012, and nothing was done to amend the regulations that provide for the national insurance credits, which are the Social Security Credits Regulations 1975. So if I can just show the court how it worked. In tab 1 of the bundle,
This is main bundle,
I'm terribly sorry, tab 1 of the supplementary.
right?
One should have, I hope the court has at the front of that, section 1 of the 2007 Act that says
Yep.
superseded.
Yeah.
Yep.
If I could ask the court to turn over, one should then have a green version.
In force. Yeah.
In force. So this makes provision for the what is called contributions-based employment and support allowance. So the income-based element of it was repealed and replaced by universal credit, but the contributions-based ESA remains. And what we see in section 1 is an allowance to be known as ESA shall be payable. And then subsection 1(2), a claimant is entitled to an employment and support allowance if he satisfies the basic conditions, and the first and second conditions set out in Schedule 1, conditions relating to national insurance, are met. So one then says, what are the basic conditions? Subsection 3, the basic conditions are that the claimant has limited capability for work. And then the first and second conditions in Schedule 1, they're very complicated, I haven't included them, but essentially it's you've paid a certain level of national insurance contribution.
Yeah.
That's not controversial.
Yeah.
And the claimant in this case, and many other students coming straight from school, will not have paid the basic level of national insurance contributions. So they're not eligible for contributions-based employment support allowance. But what then happens, and if I can ask you to go back to the main authorities bundle in tab 5, is one then goes to the Social Security credits regulations.
5 is the PSED.
6 is the
6, yeah.
AP.
6.
And
Page
just going to pause for a
49.
moment, I'm glad we noticed this. I've actually opened the authorities bundle for the hearing below. Let me open the right authorities bundle, otherwise this could cause any number of problems.
The problem with computers, you see, they just take over your life.
Well, Lord, this is the first hearing I've done with electronic bundles where that has ever happened to me. Nevertheless, we will persevere. Yes, tab 6,
Yep.
the current authorities bundle, is the credits regulations. And what one then sees is, for the purpose of entitlement to any benefit by virtue of a person's earnings or contributions, he shall be entitled to be credited with earnings equal to the lower earnings limit then in force, in respect of each week to which this regulation applies. So it's a credit. And then one sees, subject to paragraph 2A, which doesn't matter, this regulation applies to a week in which, in relation to the person concerned, each of the days, and then if one goes down to Roman numeral 4, was a day of limited capability for work for the purposes of Part 1 of the Welfare Reform Act, or would have been such a day had the person concerned been entitled to an ESA by virtue of Section 128 of the Welfare Reform Act.
Yeah.
So it applies even if you're not entitled to the actual ESA. If you would have had limited capability for work, then the individual gets the credit.
Yeah.
Right.
So that is how
That's
the
how they
workaround
enacted it.
works. One has to determine whether there is limited capability for work in order to determine whether the individual gets the national
Presumably this is
insurance.
backward looking because you have to have the credits for a period, don't you?
Well, my lady, yes. The credits become relevant if one is applying for things in future.
Yes, but you need to credit
You
for
have
the
to look
past.
back.
Yes,
Yeah.
but my lady, that's right. And there
Okay.
was some discussion before Mr. Justice Swift about how the credit system works. And if it helps, my lady, that is in the supplementary hearing bundle, the post-hearing note at page 304.
Thank you.
And there was a question in there that the judge asked about how national insurance credits work. Is at page 307.
But basically, if somebody's 19, as Mr. Kayes was, he can be credited with the national insurance contributions
To allow
get
him
ESA.
to get things in future. So looking a long way in the future to pension contributions. For women who may have children, it's an element for maternity allowance. You have to have had a certain number of national insurance contributions. You've either paid them or you've got the credits for them. So it matters in future. It works here, it has been used here as a way of getting the limited capability for work determination. Yeah. So the only way one can get it is to apply for ESA, and that's why the Secretary of State tells people when they refuse universal credit, apply for ESA. Refuse the actual ESA, but is then referred to get the credits.
And before the amendments made in 2020, the claim for universal credit would have been backdated to the date of the claim.
Well, my lady, it wasn't in practice because...
But what do the rules say? Never mind what you've been doing. We know she's not good on the law, on the facts. What does the law say? Was it backdated?
So in 2014, as it originally stood, which is at tab 8, so what would happen, one would make the application for universal credit, what should have happened, let's put it that way.
Yeah.
It didn't happen, it did not happen.
Just stick with
Let's
the law.
look at the law.
But what should have happened is that the application for UC is made.
Yeah.
Eligibility determination is then made, which says, are you entitled to any of these benefits? That's the first question, answer yes. Has limited capability for work. So there should have been a pause. One would never have needed to go around the workaround route, because what should have happened, which is what the Lordship is asking me, is that there should have been an assessment
So let's assume there's an assessment.
Under Part 5 of the Universal
Yeah.
Credit Regulations.
An assessment under Part 5.
To determine
And if you
whether the
did get your
individual-
LCW, was your claim then paid from the... Were your benefits then
Should
paid?
it have been paid?
Should they have been paid
No, I think
from the date of the claim?
Yeah. But
Yes.
the system
Yes.
never, the computer
Yes.
always said no.
Subject to, there are provisions in a different regulation about the backdating of claims for universal credit and how far back
Yes.
one.
But let's start. The 1st of January 2021, I apply for universal credit. I've got the benefits. I have an assessment which is done on the 1st of March 2021, but I get my, I should, under the rules, have got my universal credit from the 1st of January, the date I applied for it.
Yes.
It's as simple as that. You weren't doing it, but you should have been doing it, and that's what the law said.
Subject, my lord, there is a caveat. I can't give a straight yes answer because there are caveats in the Universal Credit Claims and Payments Regulations. I think it's Regulation 26 about how far one can backdate a universal credit claim. So it's not an absolute yes. It's yes, subject to the specific provisions about the timing and payments of universal credit.
And with ESA, if I was told I couldn't get universal credit, rightly or wrongly, and I then applied for ESA on the 1st of March 2021, and I'm assessed and I got LCW, I can't do that much work, and they say, yeah, you need insurance credits, and they finally credit those on the 1st of June 2021. So you apply on the 1st of March 2021, LCW 1st of April 2021, and you're credited on the 1st of June 2021. Well, the ESA is not going to be backdated, it's going to be to the future.
Why are
Because
you
we're in the
using
world.
2021? Because we've then got the 2021
No, but I'm
regulations.
trying to use dates. So that there's
Yeah,
no
but
confusion.
let's do it in 2018.
Do it in 2018, it doesn't matter,
can
just to
we
have
press on?
dates.
Yes.
We're
Let's do it in
talking about-
2018.
the court is putting questions to me about how the regulations should have worked.
Yes.
Yes.
If the regulations had worked as they should have done, one would never have gone down the workaround route.
No, let's be
Because
clear.
if
No, we're
they
not
had
saying
worked
should have.
as-
We're on the face of the
On the face of the-
regulations.
but the court is
what-
asking me how should these regulations have worked?
On
What
the
do
face
these
of them.
regulations require the Secretary of State to do?
Well, let me
Yeah.
put it in
And
a
they would
different
never.
way then.
Look, can I finish,
Yeah.
please? One would never have gone down the workaround route
Mm.
because the Secretary of State should have determined, under Part 5 of the UC regulations, whether the claimant had limited capability for work.
But there was a choice. You could either do it under
Well,
the UC or you could do it under the ESA. I can't remember which
but one would
provision
only
it
go
was.
off to ESA if one had been refused universal credit.
Right.
No, hold on. Say I haven't applied for universal credit. It's still a free country. I don't have to apply for universal credit. On the 1st of March 2018, I actually applied for ESA.
Yeah.
And that's what I do.
Right.
What would happen next under the rules? I'd been assessed for
Under those
LCW.
rules, one would get one would get the limited capability for work determination under the
Yeah.
National Insurance Credits Route.
Yeah.
But you've never made an application at that point for universal credit,
No.
so one can't. Well, one can't then backdate it.
No.
There's nothing to backdate. So the payment for universal credit
Yes,
starts from the
The
date
date
at
you
which
claim.
you make the
Yeah.
application.
Okay. So that doesn't work. Let's assume you've applied for universal credit. The computer said no, and so you go down the ESA workaround.
Yes.
Right.
Computer has said no to your universal credit claim.
And
So
then
you have to make another universal credit claim
I see.
once one has the LCW.
Yeah.
So you say you wouldn't get into the workaround
because
at all.
You
because
should
you
have
would
been
have
referred under Part. If these regulations has worked
Part
as
five.
they should,
Yep.
should have been referred under Part 5, so that universal credit claim would never have been refused.
I'm still a bit puzzled about one thing.
That's in the world where the regulations worked as the Secretary of State accepted they should have worked in Cowser.
Yeah.
Yeah.
And I'll show your lordship the statement of reasons in Cowser and the way in which the Secretary of State accepted it was unlawful, and it's precisely on that basis.
I know I'm a bit slower than everyone else, but can I just check one last point?
Yes, of course.
I've refused to apply for universal credit. I'm philosophically opposed to it. I've applied and I've insisted on applying for ESA, and I assume that's an amount of money. On the 1st of May 2018, I applied for that amount of money described as ESA.
Yes.
On the 1st of June 2018, I get my LCW and I'm very happy. On the 1st of July 2018,
Yes.
they say, yep, you haven't got the national insurance credits, but we're going to credit you with them. the sum of money I get for ESA, is that payable for the period from the 1st of May 2018 or from the date when you finally credit me with the national insurance?
Well, my lord, you don't get any ESA. You're not eligible for ESA because you
You
haven't
didn't have the
satisfied the
credits.
contributions condition.
Well, what's
So
the
you get 0 by way of ESA.
Credits
There's no.
are just
You get
notional.
national insurance credits.
Yeah.
Which
That
can be
gives you
applied
LCW.
when one is then applying for a contributions-based benefit
Right.
at some point in the future. Even though you haven't
Right.
paid national insurance contributions, you can use the credit.
That's what I thought. So the only purpose of the ESA in this exercise is to get your LCW.
Yes.
That's the only purpose.
Yes.
It's another route, and everything else is irrelevant. So that's why there's no link with the date of the universal
Yes.
credit claim, because you either not made one or it's been refused. Yeah.
Yeah.
No, I got it. I did actually know the answer, believe it or not, but I just wanted to check.
My lord, I'm sure we all believe you. My lord, I then want to take.
There's no amendment, it's just a working through of the consequences.
Yes.
Yeah.
So no
Okay.
amendment was made
Yeah.
to the 2012 Act. No amendment was made to the Social Security credit regulations. The only amendment that was made was to the Universal Credit Regulations and Regulation 14, and about the timing of when one had to have the LCW. So the Secretary of State didn't even attempt to tinker with the rules around how one got LCW as part of the workaround. My fourth point, third point, which I hope I can take much more quickly, is the fundamental difference between the legacy benefit regime and the current regime. And I think it is common ground that it's now accepted that there was a difference, but I just want to show the court why there was a difference. For the court to note, that is described in the witness statement of Miss Garrett, the first witness statement, supplementary bundle, paragraph, page 115, section D. I don't ask the court to turn it out now, I'm just going to show the court the legislative provisions. And this is back to the supplementary bundle again, please. So Zoe, it's 115. So the supplementary bundle, tab 1.
Tab.
Tab 1.
Yep.
At the front, you see the superseded
Yep.
version of section 1.
Then we
of the
looked at the
Work
one in
Act.
force.
And the essential part for that is section 1.2. This is eligibility for employment to support allowance again. When there was still an income-based ESA, this is what was replaced by universal credit. The conditions for entitlement were you met the basic conditions, and B, 2B, the conditions set out in part 2 of Schedule 1 were met. One then goes over the page, right to the back of that subsection, right to the back of that tab, I'm sorry. Internal pagination for mine is page 15. I don't know if that made its way into the court agenda.
No.
I do apologise. It's the very last provision. So it's
So Schedule 1.
Schedule 1, paragraph 6,
Yeah.
the basic conditions.
Yes.
The conditions are that the claimant, 1G, is not receiving education, so like universal credit. One then goes into tab 2 of that bundle to see what that means. The internal pagination 22, regulation 18. The circumstances in which the condition that the claimant is not receiving education does not apply, and that 6.1g does not apply where the claimant is entitled to a disability living allowance. So there's no additional requirement that they have limited capability for work, but that is one of the basic requirements of ESA in the first place, so one does have to have that. But what is different is Regulation 33, page 25, right at the back of that tab. Additional circumstances where claimants are to be treated as having limited capability for work. And one sees 33.2, for the purposes of an income-related allowance, the claimant is to be treated as having limited capability for work, where paragraph 6.1g of Schedule 1 of the Act does not apply in accordance with Regulation 18. That means when the person has disability living allowance.
Under the old regulations deemed LCW, if you get a disability living allowance, new regulations, you have to have a determination.
Yes. Well, so that was a difference that I think Maloney found accept was obvious at the point at which the consultation took place. And then my final point.
Sorry, you say that was obvious.
Well, Maloney, because it was obvious on the face of the regulations. That's nothing to do with the Secretary of State's practice. That's what the
Because you
regulations.
had to have a determination.
Yes. Or there was no deeming provision.
Yes,
that
no
triggered-
deeming provisions. You had to already have your determination before you went into the claim.
Well,
There had to be that's the issue, my lady. But
Yes.
on any analysis, there had to be a determination. One couldn't be treated as
Yes.
No, it sounds to me at the moment as if the department has gone through this kind of mindset. Previously, we deemed it, we assumed that you would get it. It's a harsh new world after the introduction of universal credit, and they're actually going to check. There's going to be a determination that you have limited capacity for work. You assumed that meant you had to have it checked before you applied, but you didn't say that.
Yes.
That's
Well,
what
that's
happened.
it. And I've never, the
After a day
Secretary's
and a
case
half.
has never been that there was a document in big flashing red lights that said, and this is how we understand Regulation 14 to work. That's never been.
Yeah, because they don't. You see, the law in this country works on the basis of what the law says,
Well,
not on what you think it
absolutely.
says.
But I'm just making it that has
But
never been.
that is the problem. It
that
says
has never
determination,
been
and you've made an assumption that the determination must predate, and the fact is it wasn't required to predate.
Yes, my lord, absolutely.
Yeah.
The final points, if I could take the court to before the short adjournment, are about the how the Social Security Advisory Committee works. And it's very important that we do understand that, because the consultation that was carried out in 2013 was consultation by that committee. It was not consultation carried out by the Secretary of State. The Secretary of State has never consulted on the Universal Credit Regulations. The Secretary of State has always done what statute required to do, which was to refer these regulations to the Social Security Advisory Committee. Now, if we could turn to that Act, which is at tab 1 of the main authority manual. Section 1 continues the committee in existence, page 5. And the function of the committee is to give, whether in pursuance of a reference under this Act or otherwise, advice and assistance to the Secretary of State in connection with the discharge of his functions under the relevant enactments. There's a very long list there, my lady. It includes the Welfare Reform Act 2012 that we're concerned with here. And it's important to note that this committee, it's not a committee made up of members of Parliament or peers. It is a committee made up of specialist members with expertise in social security.
Yep.
And one then sees at section 172, which one needs to go down a few pages to get to because there's the long list of relevant enactments, but one sees that at page 16. The function of the committee in relation to the regulations, and that is subject to section 173, which we'll come to in a moment. Where the Secretary of State proposes to make regulations under any of the relevant enactments, he shall refer the proposals in the form of draft regulations or otherwise to the committee.
Yep.
So that is what happens. And then section 173, and the heading to section 173 shows that what happens in 172 is consultation with the Social Security Advisory Committee, because 173 is headed cases in which consultation is not required. And then 173(1), nothing in any enactment shall require any proposals in respect of regulations to be referred to the committee if it appears to the Secretary of State that by reason of the urgency of the matter it's inexpedient so to refer them, which we're in here, or the relevant advisory body have agreed that they shall not be referred. And then 173(2), if it's done under the urgency route and the Secretary of State makes the regulations without the proposals having been referred, then unless the relevant advisory body agrees that this subsection shall not apply, he shall refer the regulations to that body as soon as practicable after making them. And that is again exactly what happened here. They were referred, the advisory body examines them, they subject the Secretary of State to questions, and then ultimately decide that they don't want to take the regulations on reference. So all of the statutory requirements about consultation in respect of these regulations have been complied with. My lady, it is almost 1 o'clock.
It might be worth just pointing to 174.
Yes, thank you to my learned friend. 174 is then what the committee does once it takes them on a reference. And the committee shall consider any proposals referred to it by the Secretary of State under section 172 above, and shall make to the Secretary of State a report containing such recommendations with regard to the subject matter of the proposals as the committee thinks appropriate. And I'll show the court after the short adjournment the report that was produced in 2013.
And is there a provision saying that the SAAC can consult with the public, or is it just implied in their functions? And is it common ground that the document that emanated in connection with the 23 regulations did not come from the Department of the Secretary of State, but came from the SAAC? Because I understood you to say the Secretary of State never consulted. So I'm not doubting you, Ms. Clement.
My Lord, I'll show you, Lordship, in a moment. The document is in the bundle.
It's in the bundle, right.
It's the report from the committee. The committee has a broad discretion about how it carries out its function.
Its function, so it may choose to speak to
it may
people
choose to
generally.
consult, and it did in this case.
Right, okay.
But it's the SSAC's consultation.
Yes.
You say.
In many cases,
Right.
it doesn't consult. Yeah.
Right.
Okay. Now, how are you getting on in terms of time? You lost 15 minutes,
I
but
did,
we might
my
be
lady.
able to make that up.
I've got 5 key points of the evidence I need to deal with, and then once I've done that, I can take my response on the grounds very quickly.
Shall we start at 20 past? I think I can get here for 20 past 2.
Yes.
20 past 2.
Okay.
That'll hopefully address it. Good. 20 past 2. Thank you very much.